Good. How are you today? I think I'm good up to the part where we need the statements. Well, it's like a it's not, what does it look like? That's because I was looking at it. So she's got a speaker. And there's a look like the speaker. Okay, can you read this exactly because it's 4 weeks, but oh, really? Okay, then the witness, I got that. Okay. Yeah, okay. I could do a tea or something. Yeah, like, I don't know. Yeah, then I could just call you. It's just too okay. Thank you. Have a good day. Bye. Eventually. Yeah, you might do. Yeah, just a little lighter. I just for a sec. Yeah, you're unmuted, so we're good. Oh. I'm no IT person, and this is kind of thing, but I think we got it working. As long as everything works how it's supposed to, I'm good, but if anything goes wrong.
Yeah, my expertise allows me to turn it off and then turn it back on again.
Yeah.
And some, about half the time that actually does fix it.
Yeah. Yeah.
But the other half, I'm just completely lost.
A lot of times it's I don't think that's a good idea. Talking about it.
Agreeing to defend. Agreeing to defend. We made face shields that are attached to the using their hats. And so we bought 3 of them for my dad every day.
And I'm gonna try to speak slower, and I've got a different mask than mine. Cool. Wait, what did you do? Thank you.
Yeah, I'm really happy.
You sound like my wife. I get that from her every time I say anything. Yeah, I know. And I meet you. No. Yeah. Yeah. We have a highlighted copy of this, but it's not a fair. Oh, yeah. Well, I actually.
You on the network, Rafe?
All right, yeah.
Sure.
Well,
Yes, you are.
Well, somebody that was watching yesterday said that they could only see half of the witness's face.
Which
Well,
half?
it's good at like.
Yeah.
Which would you better have?
I don't know if we tilt the screen, but I don't know which way.
Oh, is this what's filming me?
Yeah.
This laptop?
It'd have to be.
Oh.
So you kind of have to just.
So I wonder if we got you low, maybe.
You just, it might just be
Slam it down.
as much as doing that, something like that.
Yeah, I can't. I actually.
You don't see yourself.
I don't see myself on it. Nor do I want to. By the way.
Well, when you're talking.
So I can see part of it is it pointed at the judge, I guess, and then.
Now there must be a camera on there.
I think you just want to make sure that it's maybe.
There's probably.
I did that in the federal court.
I think actually if I start video, Yeah, so then that actually is pointed at me.
Oh, did it stop? It's still good.
Yeah, that's what you want to see.
Yeah, so that actually they can see all of me. I probably actually, when I had all the exhibit books, I might have actually moved that camera, not knowing that it was placed there for a purpose.
Yeah,
So
I didn't think of that either. Looks good here, though. You're like centered too. Like,
That's right. I gotta sleep. No.
oh, you know what? Not great. Just happened to notice the yesterday. You can look out. See those bags on the floor? I looked at them yesterday. Seems like a little Karen here. Yeah.
There's another one, 48, 48, or 48. Well, you know, we can use this foot or use it.
Yeah, yeah. Should have been doing this a long time ago. Yeah.
Did you just look at the outside?
And I still have all the others, but.
Yeah.
Oh, yeah. So I know that I literally the shortest days I feel like oh yeah. The whole world. Well, the beauty of this. Cheeks. No, it's good.
Wait, say that again.
Okay, well, I wanted to focus on.
No, that's true. He wasn't, you're right.
It's the right time.
He's the greatest of all time. Right.
So if I go fast, we go fast.
Absolutely. But I've got time to wait till I would go.
Oh, but speak slow. Go fast while you're speaking slow.
Speak slowly. You're fishing. Speak slowly, but ask your question.
You know, the study done that if you're listening to somebody and you're not looking at the things in their pursuit, you understand about 40% of what they say.
I bet
And the
that's
rest
true.
of the context. But if you can see them and you're looking at them, this math business, you guys, but you're probably not looking at it now.
All rise. Superior Court for the state of Washington is now in session. The Honorable James J. Dixon.
Please be seated. Thank you.
Good morning,
Good morning, everyone. Mr. Bolsini, would you be kind enough to stand and please rise? We'll administer the oath. Do you swear or affirm the testimony you are about to provide is true and accurate to the best of your knowledge?
I do.
Thank you. Welcome again. Please have a seat. Mr. Leveson, you may continue at your pleasure.
Thank you. We're trying to get the screen turned on.
Oh, okay.
I think the monitor's up. There you
Sure.
Good morning, Mr. Bellacino. How are you today?
Good.
I was just finishing up on this exhibit when we stopped yesterday. In the last paragraph, you say, I could justify a settlement, the SA case in the range of $1 million. The other 5 claims are just substantially less. So forth. Does this recommendation, does that take into consideration the $1 million policy limit?
Yes.
Okay, if the policy limit were higher, would you be recommending a higher number at this point in time?
No.
Okay, why not?
That was, at the time, that was my assessment of the settlement value of the SA case.
Okay, and at this point in time, you're not going to undersell the value. Are you going to? Oh, let me ask you. I won't ask you the leading question. Are you going to undersell or oversell your recommendations to Philadelphia as to the value of the cases that you're handling?
Can you explain what you mean by oversell or undersell?
Just are you going to tend to tell them a number at the high end of the range or the low end of the range when you're making a settlement recommendation?
Neither. That was my assessment at the time. It's not overselling or underselling it.
Okay, that was your assessment. Did that assessment ever change?
Yes.
Tell me about that.
We saw some emails, and just to give some background, there are very, very few cases regarding sexual abuse of this sort that go to trial. And, you know, I can think of only a couple that went to trial prior to when I was writing this letter. And so I was basing that on basically what cases were going for at that period in time, to my knowledge. And so in maybe August or September of 2012, as Mr. Cochran said, he got a verdict in a case against one of the Catholic orders. And based on the email, that refreshes my memory, it was an $8 million verdict, which was a lot more than I expected it to be based on what I knew about the case, which right now I have no idea what I knew about the case, but that was my reaction. So that caused me to reevaluate at least what the essay case would be worth with respect to, juries. Now, again, nothing, the issue about policy limits didn't change as a result of that verdict. So I didn't think that it created more room for us to actually settle. But that verdict, caused me to change my thinking about, how jurors view these cases.
Okay. My next question was, what do you remember about that case? And you just told me you don't remember anything about the case.
It was a case against the Catholic order, and I'm sorry, whatever I knew about that case has been lost in the last 10 years.
Do you know how many victims there were in that case?
I thought it was a single plaintiff case.
Okay.
And it was a man.
You know how long the abuse had taken place?
I may have at the time, I don't recall now.
Okay. How would you compare cases against priests in general as applicable to a case like this where you've got young children?
Oh, there's different factors to consider. And the case, and I started representing the Catholic Church in 1994. And the cardinal law scandal occurred, about 6 or 7 years later. And, that changed the value of those cases. Because before the cardinal law scandal, the church and the priesthood was not tarnished the way it was after, and the credibility of the church and the credibility of the priest was not tarnished like it was after. So those cases became, I think, much harder to defend after it became publicized that this was a significant issue with respect to the church. That's not true of, daycare employees and daycare workers. There isn't that history of, molesting children and either covering it up or recycling priests or things like that. But there were other factors in this case. Sorry.
Slow down.
Covering it up or something?
Recycling. In this case, there were other factors, and that included the very young age of the child and the extent of the abuse that he suffered. And so what I did in coming up with that range is I took what cases were going for at the time, which my understanding was about $500,000, and doubled it to account for the young age of the victim and the extent of the abuse.
Okay. All right, let's move on to Exhibit 547, please. So the last letter we looked at was in February of 2012, and this letter is in September of 2012, and this is about by this time were the covenant judgment settlement offers on the table?
They were, and I believe that signatures were in process.
On September 8th, in the big one process.
Yes.
Okay. So, if we could scroll down a little bit, here you actually assign specific numbers to each of the plaintiffs. And at this point, you're trying to make it fit within $1 million limit. Is that correct?
It is.
Okay. So how did you come up with $500,000 for SA. SA is the one that Mr. Tabor, Eli Tabor confessed to, correct?
Yes.
Okay, how did you come up with that number?
I thought that he was the most significantly damaged.
Okay,
And, you know, if the goal was not to fit everyone, including ND and his mother, into a $1 million box, I would have given him a much higher number. But the goal was to, you know, basically fit everyone within this $1 million box. So I thought that he deserved the lion's share of it and gave that $500,000. Now my analysis wasn't particularly scientific. I just remember putting them all out, you know, and with $1 million and making sure that everyone got something, which meant that in this analysis, SA got less than what I thought he deserved. I would have given him, if the assignment was to not, that I didn't have to assign numbers to everyone, he would have gotten, and most of it, his mother would have gotten something, and then the others would have gotten much more nominal amounts.
okay, well, as we go through this, Amanda Merritt, that's his mother, correct?
Correct.
And you have $100,000 for her.
Yes.
Okay. And we go down and we have ND. Now, ND is not a party to any litigation at this point, correct?
He is not.
Why was it that you were including ND on this within the $1 million policy limit?
That is what Ms. Holloman asked me to do.
Okay. Did you have an understanding whether or not Mr. Cochran could settle for his clients, all of his clients, putting ND aside, without settling all of them together? Did you have any thoughts about that?
I don't remember having any thoughts about that. I did not think that this settlement offer would result in either a global settlement or even individual settlements. And I don't remember thinking about that or having a conversation with that about Ms. Holloman. What if somebody came back and he said that JJ accepts the offer or would like to accept the offer? I mean, if that had happened, I would have said, I think you should settle with JJ, but it wasn't, the issue wasn't discussed.
Okay. And why do you say that you didn't think that this was going, these amounts were going to settle the case?
Because there was, at this point, it would seem like an intractable dispute about what the policy limits are. And at this point, Mr. Cochran had stacked up a large number of clients. One of those claims was very substantial. And I just didn't think that unless there was some kind of determination that this is all the money there is, a legal determination, that which wasn't going to happen anytime soon, then the possibility of settlement within these policy limits was remote, if not impossible.
Okay. Just going down the page here for some of the other people here. So for ND, you have the 125, and do you have an understanding of why you were asked to include ND? You said because the claims adjuster asked you to, but do you have any understanding why ND was being included here?
I don't recall that she actually explained why in the email. I did advise her at one point that Mr. Cochran was representing ND. At some later point, she got information either from me or somewhere else that Mr. Cochran was not representing ND and his mother. I assumed, and this may have turned out to be incorrect, that I assumed that if claim was forthcoming, if not by Mr. Cochran, then by another counsel that she had hired. It was a remote possibility for me that ND would not actually bring a claim.
Okay.
And I appear to have been wrong about that.
So if ND wasn't included in this $1 million policy limit, allocation that you're doing here. And the case has been settled for $1 million without ND. And ND then brought the claim that you expected ND going to bring. There wouldn't be any coverage left, right?
Well, that was my understanding, is that basically Philadelphia could basically walk away from any obligations for defense or indemnity.
Okay, so it was actually in your client's best interest to make sure that the settlement, the use of $1 million, would go to all known or potential claimants.
It is leading, sustained, but you can rephrase, Mr.
Yeah.
Davison.
Was it your understanding that Philadelphia is trying to protect the client by making sure that all the claims, actual or potential future claims, were included in $1 million?
I don't know what Philadelphia's motivation was, but I thought that that was in the best interest of the clients. If there was a settlement, that it be global and include ND, based on my belief that ND was coming forward with a claim at some point. And there was a difference of opinion between me and Mr. Ashbaugh and Mr. Meyer on that issue that played out a little later.
Okay, well, tell me about that. I don't know what the answer is, but I'm just interested. How did that play out? This was in response to the $4 million settlement demand, and Mr. Ashbaugh and Mr. Meyer decided to communicate with Philadelphia that they wanted that demand to be accepted. $4 million.
The $4 million demand, that it was what plaintiffs considered to be the policy limits. And I was concerned that if that demand was accepted, which I didn't think it would be, but if it was, then, and Philadelphia said, okay, those are our policy limits, we accept the settlement demand, and then ND would come forward, then there would be no defense or indemnity. And then later, the demand was reduced to $3,995,000. And again, I don't practice in this area of insurance coverage. And then at that point, I think Mr. Ashbaugh and Mr. Meyer made a similar demand for Philadelphia to accept it. But I thought, well, what does that mean that if ND comes forward, there is money for defense, but there's only $5,000 that could be used for settlement? And how would that affect OELC? Because OELC did have that $300,000. So, and maybe I was overthinking this, but I thought that, in order to demand that a policy limits demand be accepted, it either should include ND, or there should be at least enough money to make, a decent settlement of ND's claims if they were brought. And I'm not a coverage attorney, and Mr. Ashbaugh and Mr. Meyer disagreed with me on that decision.
Okay. Speaking of the $300,000, at any time did OELC offer to contribute that $300,000 to try to get the case?
No, not to my knowledge.
Was it your understanding they were already, during your tenure as defense counsel, that one of the goals of OELC was to preserve that asset?
I don't remember any discussions on it, but yeah, they never said that, hey, we've got this $300,000 if it's necessary to use it for settlement purposes.
Okay.
And I never asked them that question.
Okay. And by the time we hit September of 2012, the Learning Center is no longer in business, correct?
Right. I think they went out of business in October of 2011.
Okay. And do you have an understanding of why they wanted or needed, or how they were going to use the $300,000?
I have no idea.
Remind me, you told me yesterday, but remind me, how Is that what was left over when they wound down the business and sold the property?
I don't recall there being anything left over when they wound down the business. I think they were operating at a loss for some time. That was the proceeds from the sale of the property, and it's West Olympia daycare house.
Okay, let's just go further down here. So you had 125 for ND, and ND is another victim, not included in the lawsuit as a plaintiff, but ND was one of the other victims that Eli Peter he had not been accused of molesting, but he voluntarily admitted to under a polygraph that he had also molested him.
I thought that he had actually admitted that when he was talking to law enforcement. He was charged with both molesting SA and molesting ND, and the polygraph was done after the charges.
Okay.
So I thought that he disclosed that to law enforcement, not for the first time as part of the polygraph.
Okay. And then Grace Johnson, JJ, you have 45, and Grace Johnson, and what the parents, you have 25, correct?
Yes.
And those numbers are within the range you mentioned yesterday that you thought all of the other cases other than SA were somewhere in that range, correct?
Yes.
Okay, I'm going down the page for JS. You have 30,000 and 20,000 for the parents, correct?
Correct.
And that's in the same range. And SP, in the parents, you have $30,000 and $20,000 in that range, correct?
Yes.
Going down, you have AK and parents at $10,000, correct?
Yes.
And then you have MM and parents 15,000 and 10,000.
Correct.
Okay, is that it?
Yes.
Okay. And again, you're trying to fit these within the $1 million limit. If there were no limit, how would these numbers change?
Well, at the time that I wrote this letter, the SA number would have gone way up, probably triple to 500 instead of 500,000, like $1.5 million, maybe to 2 million. And the other numbers probably would have about doubled if there wasn't so let's just say $3 or $4 million were the policy limits instead of one.
Okay, thank you. Let's go to exhibit 551, please. So 550 dated the next page, September 19th. It's a letter from you, correct, to Mr. Parker.
Yes.
And is this the offer? So what is this letter?
This is actually it. Ms. Holloman approved my allocation and said, make these offers to Mr. Cochran. And so I did.
Okay, all the same numbers that we just looked at?
I hope so, because that was the direction.
I have them up, and I think they do add up to $1 million. So good job on that. And at the top, you say with the following recommended allocation, if the plaintiffs, with the help of their attorneys, wanted to reallocate things, would that have been okay with you?
Yes, that's the way. Well, that's why it's phrased as a recommended allocation, as opposed to individual offers that were set in stone.
Okay, is there a reason why you broke it down instead of just saying you went off with $1 million and what you allocated? Is there any science or rationale or thinking about that?
That was the direction from Ms. Holloman to do it this way.
Okay. Did you think it was more likely to accept the settlement? Or what is your understanding?
She did not disclose why.
Okay.
And I'm not familiar with settling cases this way, except back at Perkins when we did air crash litigation, where they would, the defendant would actually make offers like that. They would say, $10 million for everything you got. And then it would be up to the plaintiff's attorney to allocate that. But, I've never done that in a context like this. So.
Okay. Good. So when you said on the SA claim that you would have maybe tripled the $500,000 to $1.5 million, that's more than $1 million that we looked at back in February on exhibit 514, right?
Correct. And I as I mentioned, I was influenced by a recent jury verdict that Mr. Cochran got on one of his Catholic cases.
And that was the Oblate Fathers case.
I'm sorry?
Oblate Fathers?
It was a Catholic order. I don't remember which one.
Okay. Yesterday, we mentioned a report from Mr. Logan, who had conducted an interview with Eli Tabor from the jailhouse. Remember that?
Yes.
And if I remember correctly, Mr. Cochran's office provided that report to you.
Yes.
Any other reports, expert reports, ever provided to you by Mr. Cochran prior, anticipating the 3 trials coming up in the following month?
No.
Your understanding that the report was provided to you because it would somehow influence settlement values of the case or the ability to settle?
It was just it came with a cover letter saying, "Here's a report." It didn't actually draw my attention to why it was being provided to me.
Okay.
I read it and I had an opinion about that, but it wasn't explained why it was sent to me.
What was the substance of that report?
Well, it was basically he did an interview and did some psychological testing of Mr. Tabor in prison, and then he was giving his psychological opinions about Mr. Tabor's psychosexual history and present.
Okay. Other than focusing on Mr. Tabor and his sexual dysfunction, is there anything else in that report? Can you talk about any of the victims in the case, his damages, anything like that?
I don't recall that, no.
Okay. Did it ever occur to you that you would have wanted to or needed to depose Mr. Logan based on what you read in that report before the trial came up the following month?
For the record, it's Dr. Logan.
I'm sorry. Dr. Logan.
Oh, I think it would have been a prudent practice to depose him. I mean, his report was pretty specific about what he had to say, and there was one part of it. I mean, most of it was duplicative of what Sue Batson did when she was evaluating Mr. Tabor for SOSA. So most of it was just duplicative of that. There was one part where he said that even though Eli Tabor said that he had no sexual contact with women or no sexual interest in women, he thought that he, could be disturbed enough to have molested the 2 girls, which I thought that was the whole point of the report that was being shared with me, was his opinion that he does things that he doesn't like, and so therefore he may have molested two girls, even though he doesn't like it. He doesn't like women or girls.
And why did you think that was the point of sending you the report?
Well, that was the other stuff in the report seemed to be duplicative of Sue Batson's report, and actually Sue Batson's her deposition had been taken, and then also to there's another part as well where he casts doubt on the polygraph and says that the polygraph examiner didn't ask him specific questions about the two girls or specific questions about particular victims.
Okay. We ever provided copies of reports from Dr. Conte and Dr. Wago?
I didn't hear the second name.
Wago.
Oh no.
Have you ever heard of Dr. Wago before?
My current memory is no. His name doesn't ring a bell.
Okay. You mentioned back in September, when we were last year, that there were a few expert witnesses that were disclosed by the plaintiffs that you didn't think were going to testify about issues that you didn't believe were the proper subject of expert testimony. Do you remember that?
No.
Okay,
I'm sorry.
was that a specific?
I do sort of remember that topic coming up.
Okay. What was some specific subject matter being discussed? And you can't remember it, I'll move on. Do you recall that Dr. Wago was ever disclosed as an expert witness by the plaintiffs prior to the planned trials against OELC in October 2012?
I'm sorry, I don't recall.
Okay. You testified yesterday that the client's personal counsel, Mr. Ashfall, will be filled up his position on a $1 million policy limit was a defensible position. Remember that testimony?
Yeah, I don't know if he phrased it that way, but part of his role was if he thought the Philadelphia policy provided for greater coverage limits than $1 million, that he was going to advocate for that with Philadelphia. And I mean, other than saying, we want you to accept this $4 million demand, I don't recall seeing anything from him where he put together a legal argument for Philadelphia saying you're underestimating your policy limits in this case.
He did not do that.
I don't remember seeing anything like that, which would have been consistent with what he told me was that the way he phrased it was, based on his view of the language, his knowledge of the law, that Philadelphia had the better position about what his policy limits was.
Okay. And did he tell you this before or after your clients entered into the covenant judgment settlement? That
was before. That when he was originally retained, I sent him the Philadelphia policy and maybe some other policies that Steve may have had to say, is there any other sources here that could be used to settle these cases?
Okay. Excuse me for a minute. Could you describe to me what your understanding of the United States District Court action that we refer to as the interpleader action? What is your understanding of what Philadelphia was trying to accomplish?
Oh, my understanding is very limited, and that was it's basically the understanding of what interpleader is, which I learned about as a first-year law student in 1986, and that was that there is a pool of funds. Here it would be Philadelphia's belief about the policy limits, and you go to court and you say, here are our policy limits, and you have this court proceeding to essentially allocate them to anyone who has a valid interest. So that's my understanding of what this interpleader action was about.
Okay, if you scroll down here, this is an order granting summary judgment on the issue of policy limits for wait and go back up again.
You want to identify that exhibit, please, Mr. Leveson, just for purposes of making a record?
Thank you, Your Honor, 643.
Thanks.
Yeah, for purposes of making the record, I'll make the objection that this aftermath event is irrelevant to these purposes.
Thank you. Overruled.
Okay, and here it says, PIIC, that's Philadelphia, and please refer to it throughout this hearing, seeks the declaratory judgment that the policy provides only and exactly 1 million in coverage. See that?
I do.
And that's part of your understanding of what Philadelphia is trying to accomplish. That's following the interplay, is correct?
No. I at the time I was aware that I didn't know that there was going to be a coverage determination as part of the interpleader. So I have read this, so I'm familiar with what it says, although it's been a long time since I read it.
Go down a little further. Let's go to the bottom where you make the decision. It goes through an analysis, like policy provisions, and let's just go to the bottom. The bottom line is to say, okay, that's good. No, yeah. Okay. And he says the subject policy language is not ambiguous and is not susceptible of more than one reasonable interpretation. No question about completing a rule. And we find that the limits are exactly only $1 million over multiple policy periods. See that?
Yes.
When did you first become aware of this position?
It would have been shortly after it was decided,
Okay.
and I think actually Will Ashbaugh called me and told me that there was a decision, and I don't know how he was aware of it.
Okay, and this is in October 16th of 2013.
That's what the document says.
Okay. Do you think it was a good idea for Philadelphia to try to resolve this impasse between OELC and Philadelphia on the one hand, and plaintiffs on the other hand, about what the policy limits were, to try to get the case to a settlement?
Yes.
Why do you think it was a good idea?
Because that was the impasse that I saw with respect to resolving it, is that there could be no resolution when, given the substantial value of the SA claim, there could be no resolution while Philadelphia was saying our policy limits are 1. The plaintiffs are saying policy limits are at 4, and this is a critical part for me that it's not like they're suing Microsoft, where there's an unlimited number of assets that the defendant has. They're suing a defunct local daycare and 2, daycare employees. So the policy limits is really the primary, if not exclusive, source of actually settling the case. So I just thought that I agree that needed to be resolved if there was going to be any meaningful settlement talks.
Okay. I'd like to ask Mr. Connolly when he testified in this hearing. I know you're not an insurance coverage expert, but you do work for insurance companies, at least when they hire you to protect their policyholders. Yeah.
No, not currently. I have not since early 2015.
Okay. You're doing that at this time. Correct?
Yes.
At the time, this case, in 2011, 10, 11, 12.
Yes.
Okay. And based on your understanding, working on cases back then, was it your understanding that insurance companies were obligated to offer more than the policy limit to settle on behalf of their policyholders?
It was my understanding that they were not. That was their financial commitment to the defense.
Thank you. Was there ever a reservation of rights in Philadelphia, by Philadelphia, to your clients in this case?
No.
They were defending without a reservation of rights?
Yes.
They had always committed to pay the policy limit to resolve the case, whether it went to trial or whether they could settle before it went to trial.
Your Honor, objecting is leading.
That is the leading question. You can rephrase, please, Mr.
Thank you.
Davison.
Is it your understanding that Philadelphia, because they had not reserved rights, was committing to pay the policy limit, whether the case went to trial or whether the case settled?
Your Honor, the that question is still a leading question.
Your understanding?
Overruled.
The short answer is I don't know if failure to make a reservation of rights is committing to pay the policy limits. I know that the letter that we saw before is when they were offering the policy limits, and I was not authorized to make any offers to settle prior to that. So whether not making reservations rights is that commitment, that's probably a factual legal issue that I don't know enough to answer.
Okay. If the case was only, I suppose if the case wasn't worth $1 million, the case would have to be worth that much, and they would have to believe it was worth that much before they would pay that much. Correct?
Probably, yes.
Okay, well, that makes sense. Your answer makes sense. I'm giving your analysis of liability and damages for each of the plaintiffs. If you feel like the $1 million settlement offer, even though it was near you somewhat futile, unlikely to be accepted, do you feel it was a good faith settlement offer?
Given the policy limits and the other assets available to settle, yes.
Did your clients or their personal counsel ever demand the Philadelphia pay more than $1 million to resolve the claims against them?
Yes.
And when did they do that?
It would have been in the time frame of either August or September of 2012 that they, I think, first demanded, and this was OELC and Steve Olson demanded that Philadelphia accept the demand of $4 million and then later accept the demand of $5,000 less. But and that was done in correspondence, and it was either in the August or September 2012 months.
So your understanding that's one of the reasons that the interferer was filed?
I did not make a connection between their making demands and the interpleader being filed, so I don't know.
Okay.
They all happened around the same time, but no one said because OELC and Mr. Olson have demanded that we accept this demand, we are filing interpleader. No one actually said that.
Okay. We looked at the $1 million offer that was made, the one that you indicated had a very improbable chance of actually working. That was Exhibit 550 with the box.
Yes.
Allocation in there. What was the response to that? Did they respond at all?
I know it wasn't accepted. I don't know if it was, if there was a rejection to it that was served in writing. There may have been.
Okay. Was there an offer by Philadelphia to mediate?
I recall seeing correspondence about that, and I think it may have been correspondence between Mr. Rosner and Mr. Cochran that that they were offering to mediate.
Pardon me a minute, we're looking for exhibit 640. Okay. And if you scroll down, just one page by page, right? 12 to 13. So this is the letter to Mr. Cochran by Mr. Rodman on behalf of Philadelphia.
648,
Get the date on that as well.
Sure.
September 21, 2012.
Okay, let's scroll down, please. Okay. And here it says Philadelphia has repeatedly offered to engage in mediation in order to try to resolve this issue and the claims against Philadelphia's insureds. However, so far you have declined Philadelphia's invitation to engage in mediation and have failed to provide any case law or legal analysis supporting the position that the applicable policy limits exceed $1 million. Is that what you're referring to? With the correspondence you remember having seen about Philadelphia's offer to mediate?
Maybe. There may have been something prior to this where Mr. Rosner is saying that Philadelphia is willing to go to mediation. So the way this letter is postured, it looks like there have been communications between them prior to that, and I may have been CC'd on those, either emails or correspondence.
Okay. We'll get to the bottom. I do think you are CC'd on this. We'll get to the bottom and take a look in a minute, but just going through this letter a little bit more methodically, the next paragraph says, so recently Philadelphia has not been able to make a policy limit settlement offer because of the existence of known potential plaintiffs not included in your settlement demand, namely Andy and his mother. Philadelphia and its insurers agree that it is in the best interest of our insured to attempt to settle Andy and his mother's potential claim in addition to your other claims, the other clients' claims, within policy limits so that our insured personal assets are not exposed in a future claim by Andy and his mother after all the insurance limits have been spent. Does that reflect your understanding of why Philadelphia requested you to include Andy in the $1 million allocation exercise that they asked you to do?
It does not refresh my memory. I just don't remember communications with Philadelphia on that issue.
Okay. Because the settlement offer will be conveyed to your client so that you will communicate a response to Mr. Bolton. Was the response ever communicated to you, Mr. Bolton?
I don't recall. I mean, there was never a positive response communicated to me. So I'm aware that this did not work to either set up a mediation or settle the case, but I just don't remember how that was communicated to me.
Do you have any way of knowing whether the settlement offer was communicated to the individual client?
To Mr. Cochran's clients?
Yes.
No, I have no idea.
Let's keep going down. Philadelphia is interested in trying to settle all claims and identify the likely future claims against its insureds within the insurance policy limit. Philadelphia has offered the full $1 million policy limit in settlement. They've asked you to provide us with an explanation for your assertion that there is more than $1 million limits available under the Philadelphia policies, in light of the policy language quoted above. They've also filed a declaratory judgment interpleader action asking the court to decide what limits are available and how those limits should be distributed to the individual claimant. Your understanding that at this point in time, again, what was the date on this? September 21st?
Yes.
September 21st, Philadelphia trying to settle the case. But in September 21st, what's going on with respect to the covenant judgment?
I believe that they are finalized and signatures are being gathered.
Okay.
That's,
Do you know whether Philadelphia knew what was going on with covenant judgment offers and acceptances and all that stuff?
at some point, I informed Mr. Rosner that all the plaintiffs and all the defendants agreed to the covenant judgments. But I don't know when I conveyed that to him. It may have been before or after this letter.
Okay. And here at the bottom, please let us know if you have any questions regarding the applicable limits of the Philadelphia policy, any other issues in connection with this matter. Also, please advise if you're interested in pursuing mediation or any other form of alternative dispute resolution. See that?
I do.
Okay. Did you ever, was there any, at this point in time, was there any discussion about trying to mediate the case, trying to go to some other kind of form of ADR, try to get the case resolved?
Not involving me.
Okay. All right. So next I want to talk about covenant judgment. And there's a separate office made for the plaintiffs there.
Yes.
They're all made. They're all made.
Yes.
And they happen to. And if you totaled them all up, where do they go?
My memory is 25 million.
What is your understanding of how 25? Why the number was 25 million?
That's the number that Mr. Cochran in his office put in in the covenant judgment.
Okay. Was this presented as negotiable or non-negotiable settlement?
I don't recall. I do recall conversations with Mr. Ashbaugh whether we should negotiate or not.
Okay. What did you decide?
His advice was there's no incentive for us to negotiate. It's in the best interest of the clients just to accept the numbers that he put in.
Okay. When the offers came in, did they come into you? Did they come into Mr. Ashbaugh? Remember?
I don't. I don't recall who they were initially sent to. It may have been one of us, or it may have been all of us simultaneously.
Okay. Do you believe that the amount, $25 million, reflects a reasonable value of the plaintiff's claims based on your evaluation?
No.
Was your evaluation ever close to $4 million?
No, not at the time that we settled.
So was there any negotiation between your clients represented by personal counsel and Mr. Cochran and his client on the $25 million amount?
No, I mean, not to my knowledge, and that would be contrary to Mr. Ashbaugh's advice on whether we should negotiate the amount or not, given the terms of the covenant judgments documents.
Okay. What were the benefits to your client and Mr. Ashbaugh's of the $25 million covenant judgment?
The litigation ends, and there's no well, originally the covenant judgments didn't expressly exclude any of their personal assets from plaintiffs seeking recovery, and then Will actually Mr. Ashbaugh actually contacted Mr. Cochran to have that language inserted. So after that language was inserted, then it was the litigation all ends. They're out, and their personal assets are no longer at risk.
Okay. Your clients had to pay the $25 million amount out of pocket.
I'm sorry?
If they had to pay, if your clients had the money, you had to pay to settle this case out of pocket. Would you have recommended that they pay $25 million?
Well, that would be an its absurd recommendation given the assets that they had. So them paying $25 million would be an absurd suggestion.
Okay.
It was never considered or thought of or discussed.
Okay. Was there any downside to your clients that are into this covenant judgment settlement or anything?
No, and the thing is I've never done anything like this before, and so I was a little incredulous that this could even happen. But I did not see a downside to them signing the covenant judgments, given that it ended all the litigation and their assets were no longer at risk.
Why were you?
Well, it just I just didn't think that you could, end the litigation and basically, shift all the risk and liability and damages to the insurance company that easily. And given the intractable dispute about policy limits, that it seemed to me too good to be true. And Mr. Ashbaugh said that it was actually some of the language in the covenant judgments that he thought, made it too good to be true for our clients.
Okay. Well, other than negotiating some of the terms of the releases, who was released, what was released, any other negotiation on the amount, the $25 million amount?
There was no negotiation on the $25 million amount. So there wasn't no other negotiation. I just think we accepted the numbers that Mr. Cochran and his office inserted.
Okay, and if the number had been $30 million, that made any difference to your client's position as far as you can tell?
Based on Mr. Ashbow's advice, we didn't care what the number was. Given the way these covenant judgments were structured or phrased, the number was irrelevant to us.
Okay, should have been $50 or $100 million, it wouldn't matter. Yeah,
That's my understanding.
So the trial against the Learning Center was coming up shortly after the covenant judgment entered. But as we discussed yesterday, the trial against the individual, Ms. Cordell and Ms. Olson, was still 8 months away, correct?
Approximately. It was spring of 2013. So.
Okay. And those were the assets that were most important to protect in terms of getting the case settlement. Agreed?
Well, Ms. Hordahl really didn't have any assets. Mr. Olson had a small nest egg.
Okay. Well, we looked at some documents yesterday that talked about a divorce. He was trying to, wife was looking to divorce him so that her assets potentially could be protected. Do you remember?
Yeah, after they were served by Mr. Cochran with the individual lawsuits, his wife said, "Okay, that we're getting divorced," and I counseled them through that.
Did they get divorced?
They were not divorced. I mean, I haven't had contact with them probably since 2012, and they were not divorced at that point. I don't know about since.
Okay. Was the idea of divorce for her to protect her assets?
Well, yes, that's the way it was posed to me.
Okay. Was there more to it than that?
Well, I didn't know. I'm not a marriage counselor, and I've never had that reaction before. So my suspicion was there might be more to this issue than they were served with the lawsuit, but that's the only issue that I dealt with.
Okay. Did you feel like you had a comfortable amount of time prepared for those the April trial schedule?
Yes.
With respect to Olson and Hordahl.
Yes.
Are there any Learning Center members, board members, named in any lawsuit?
No.
Any other potential defendants out there?
Well, yes. I mean, if they wanted to name other managerial or supervisory employees that were involved in the supervision of Eli Tabor, there were others that they could have named as well.
Okay. So those people that would have any meaningful access to their judgment?
I don't know. I was told when I testified in September that the cook would.
That what?
I was told when I testified in September that the cook would. But I had no idea what her settlement was, and I had no idea about the financial situations of the other employees.
With respect to the trial against the Learning Center, it's coming up in about a month after the covenant judgment settlement. If your readiness to go to trial influenced in any way your recommendation client that was in their best interest to settle for the $25 million.
Well, they weren't agreeing to settle for $25 million. They were agreeing to sign the consent judgments that totaled $25 million. And again, as I said, it looked to be too good to be true, with no real downsides to them. So no.
Okay. When the offers were made, were any restrictions placed on you with respect to what information you could share with Philadelphia Insurance or its counsel, attorneys that have filed the affidavit?
When you say when the offers were made, what do you mean?
The covenant judgment offers were first made. You asked, were any restrictions placed on you with respect to telling Philadelphia what was going on? If you remember.
Well, Mr. Ashbaugh advised me that the covenant judgments, Philadelphia Insurance Company and the Recoveries Council, we were not to involve them in the process. So they were not involved in, negotiating the covenant judgments or the amounts or anything like that.
Do you know what Philadelphia knew or didn't know about the amount, about the covenant judgment offer?
After they were agreed to?
No, before they were agreed.
I'm not aware of what they knew. I don't remember communicating with them about the terms of the covenant judgments or anything like that.
Why did you not communicate anything about the terms of the covenant judgment to Philadelphia before they were filed?
Because Mr. Ashbaugh said, advised me to leave them out of the process.
Okay, that was my question. Any restrictions placed on?
Well, he didn't. I mean, he didn't place a restriction on me. He just said that this is the way we should handle it.
Okay. Anybody else ask you to keep Philadelphia out of the loop? Other than Mr. Ashbaugh?
Not that I can recall.
Anybody ever ask you not to share your files with Philadelphia?
Not to share my files. So
Your litigation file. In your office with Philadelphia. Once this whole process started.
I was just vague as the time I'd ask to get more specificity.
Mr. Levison,
On August the 1st May until anytime thereafter, anybody ask you or tell you do not send your files to Philadelphia?
my memory on this is vague, but I think at some point Mr. Cochran's office, because what I understood is sort of once the consent judgments were all finalized, then in some ways I was switching sides, and therefore I should cut off contact with Philadelphia, and if they wanted my files, they should go to Mr. Cochran's office in order to get them. That I should not send them my files on my own.
Mr. Cochran's office asked you not to be.
Well, my memory on that is vague because I also remember talking about this with Mr. Ashbaugh, and so it may have the demand may have come from Mr. Cochran's office, and then I checked with Mr. Ashbaugh, and he said that's correct. Don't you're no longer an attorney. You're no longer an attorney that is working for Philadelphia on behalf of these clients. So something like that.
Okay. If you stop building time, what government judgments were finalized?
Yes.
When you just mentioned you basically switched sides, can you unpack that a little bit for us? What do you mean by that?
Well, there's something in the covenant judgment that said that that if we sign it, the parties and their counsel must support be in a position to support the covenant judgments. So that I thought would put me at odds with Philadelphia.
Do you understand that your client's rights were assigned against Philadelphia under the policy that were now
Yes.
assigned to Mr. Thompson's client?
Correct. And I actually met with Mr. Cochran in his office, like September or October of 2012. It was probably October. It was probably after those covenant judgments were signed. About then contacting, for example, Rose and Steve Olson and John Masterson and informing them that they had switched sides, and if they get contacted by Mr. Cochran's office, that they should cooperate with him.
Okay. What else did you discuss when you met with Mr. Thompson?
We discussed that, and I remember a lengthy discussion about my former law partner who was being prosecuted to be a serial rapist. So that tells me about what time period that meeting was. Those are the two topics I remember.
At the time that the covenant judgment offer was made, or any time thereafter, were any promises outside of the written covenant judgment agreement made to you personally?
Not to my knowledge, no.
In the time, any time after the covenant judgment offers were made, were there any expressed or implied threats made against you personally?
No.
At any time when the covenant judgment settlement offers were being considered, did anyone, whether it was Cochran's office or clients or personal counsel, ever suggest that you were out of position to go to trial on the first two cases?
I was what?
Out of position, unprepared.
I don't recall that.
Back at the time of the offers were made and accepted, was your preparedness and readiness for trial ever considered by your client or the personal counsel that you know of in trying to decide to settle the case?
Not to my knowledge, there were no discussions about that.
This was just all about the money, protecting themselves. That's a leading question.
Sustained.
Oh, I'm sorry.
In the first case, it was going to trial a month after covenant judgment settlement. If the case hadn't settled, were you planning to seek a continuance? Try to get the case into mediation?
Yes, that would have been, we had a conference arranged for the next Friday. And I would have raised that at that conference. Or I'm sure if the case had not concluded with the judgments, the consent judgments, then I would have raised that at the conference based on the Judge McPhee's comments for the pretrial conference a week before.
Okay. Good bit. 561.
Well, let's take our morning break. It's 10:14, so our court's in recess until 10:34.
Thank you.
Oh,
rise.
That's all. But that's not able to.
Oh, I'm, okay.
Because otherwise, I don't think
Looks like it plugs something. Oh, that's like. I don't know if you could do. Yeah, I'm not. Probably needs a little longer. But they must, somebody must have used it.
There's ports on the back here.
Oh,
Right there. There you go.
yes. So you can see it's these are the side of to or allegedly.
Just a joint.
Yeah.
Never heard that name before.
Three ones London.
Oh, okay.
So I was walking in all week, was telling me about that, and then it's three ones that day. This one. Click and then-
Oh. No. Swing up.
Stop date for this, September 1990. About 30 years or so.
Probably one of those guys who grew up at the house. It's so like.
Yeah.
Yeah,
Together. You might have shade. No, boy. I came straight from Vietnam. On the way. I did. Said hello and told me how about it. was a good one. He was also interesting because signed up so we got those like before we crossed the border. So literally we had people were handed over so that we could get to and from like this Northwest maybe, you know, yeah. Yeah. Kind of like right. You do it a little more challenging right now. Yeah. Pretty good. That's great. Stuck with it then. Oh, yeah. You gotta get it myself. He's actually really well. So he has a he's all set. He's got a natural balance, natural and so kind of sounded softer. Yeah. Yes. All right, so sign it up and see what we can do. Team that was 3 hours, 2 days, per se. We want to get it out. This is out Blackfield, so it's on Land Drive. All that industrial, it's on the direction, so I'm doing one video. So, yeah. Oh, that's great. Yeah, we don't, it's not a, I think that it's getting all the kinds of bolts. So, it's not parallel bars, elements, things like mark people. Okay, I'm still thinking one time. Yeah, great. See. Yeah, I think. Yeah. Reasonableness. Some of mine, not me. Yeah. I got it. All right.
You're welcome.
Are you planning on getting court through lunch?
Well, I hope not. You know, it's a bit late on this. It's good, but
You go to the paper, you can quickly.
I get it.
It's 40 days. That was all. Yeah. You let me walk up there and walk around the key.
Can we get that exhibit back up there?
Yeah, I gotta get the screen back
Can
on.
you put the screen back on? Okay. Probably get it. It probably timed out.
September 24th. All right. Yeah.
We started talking.
Well, we're gonna need to do that. One of the, one of the people, it's too boring.
Right, so you can't choose.
Yeah, that's good. All rise. Court is in session.
Be seated, thank you.
Mr. Levinson, you may continue.
Okay, I'm gonna move along here. We've got up here exhibit 561. I'm sorry, email.
It appears to be an email that I wrote to Mr. Cochran after the pretrial conference with Judge McPhee on September 14th, 2012.
Okay. And what was the point of this email?
He had not appeared at the pretrial conference that day, and Judge McPhee asked me to communicate a certain message to him, and I was doing so.
Okay, what was the message?
Judge McPhee was unhappy that we had not attended a mediation. That day, I think, was the deadline for mediation, and he was unhappy that we had not attended. And he made statements about, you don't no trial without going to mediation. Judge McPhee also communicated that he was going to be out of the office or out of chambers for a period, and that he had put us on the pretrial calendar for the next Friday.
Okay. And is the email you were referring to earlier where Judge McPhee said no trial until there's mediation?
I was referring that at that point to the transcript of that pretrial conference. I'd forgotten that I'd actually sent an email to Mr. Cochran following that.
Okay.
So this refreshes my memory that I did memorialize that pretrial conference with an email.
All right, we're done with that. We'll move on. I would like you to talk a little bit about your experience with Philadelphia in terms of their controlling what you did as defense counsel. Did you generally explain to the court, what, if anything, Philadelphia did to control the defense of the state?
I don't recall anything.
Did you put any restrictions on you on what you could do?
Not that I can recall.
Did you feel as though Philadelphia allowed you to decide what was necessary to defend your client?
Yes, I don't recall any restrictions or limitations put on by them.
Okay. Did Philadelphia ever ask them before you took depositions or filed motions or anything like that?
I don't recall that request.
I'm sorry?
I don't recall them making that request.
Did you ever make any requests to Philadelphia that they turned down in terms of defending the case? For example, hiring an expert.
No, not that I can recall.
Did you ever refuse a request to conduct lay deposition?
No, not that I can recall.
Did you ever deny a request to file a motion or respond to a motion?
No, not that I can recall.
Did you ever restrict in any way on written discovery?
No.
Philadelphia ever suggest that you slow down your efforts to defend your clients during your tenure as defense counsel?
No.
Philadelphia ever suggest to you in any way that they wanted to control the defense of the case?
No.
do you recall how many times plaintiffs, Mr. Cochran's office, on behalf of the plaintiffs, offered to settle the case for $4 million or $3.95 million?
I don't.
More than once?
Yes.
You know approximately how many times they've been?
I don't. I mean, I do recall a conversation with Mr. Cochran and then a follow-up letter to that. I don't recall receiving the December policy limits demand. I do recall receiving the July policy limits demand. That was for $4 million. I do recall that in the August-September timeframe, there was a demand for $4 million and then a demand for $3.95 million. So 3 or 4 times.
All right. Have you ever been involved in settling a case where insurance coverage is involved, where the insurance company paid more than the policy limit?
No. Not that I can recall.
When you first learned of the $25 million covenant judgment settlement demand, even though in your words you were incredulous, did you feel like you had an ethical obligation to your clients to recommend that they consider that entering into that covenant judgment settlement?
Yeah, and at that point in time, Mr. Meyer was advising OELC, Mr. Ashbaugh was advising Mr. Olson. But as to Ms. Horgdahl, I thought it was a really good deal. And so, I mean, I don't know if I thought I had an ethical obligation to do so, but I thought that was my sincere belief that there were a lot of good things and I couldn't think of any bad things that would come of her actually signing.
We kind of went over this, but I want to just confirm this. Did you ever tell Philadelphia when you first received the covenant judgment settlement offer or you learned about it?
I don't recall.
You know if they ever did you ever tell them what the amount of the offer was?
I know at one point I communicated to Mr. Rosner the total amount of the consent judgments.
At what point in time did you do that?
I don't recall. It may have been after the deal was done. But you know, there were a lot of things happening in that time frame, so it was a verbal conversation.
Okay.
That I'm recalling.
Did Philadelphia ever tie your hands in any way or prevent you from doing anything that you wanted to do in your defense of your clients in this case?
Just the mediation.
Just the mediation?
Correct.
Before the covenant judgments entered into, your understanding that Philadelphia was going to go to mediation?
Your Honor, the objection will lead forward the question.
Overruled.
Yes, I was aware that Mr. Rosner had said that Philadelphia was willing to go to mediation.
Okay. And what was the response to that from the plaintiffs?
I think the response from Mr. Cochran was no, thank you at that point.
I get just confused about the timing because I just want to make it clear that I could September 21 was after the point at which the defendants were even executing consent judgments. That was the letter from Mr. Rosner.
You can ask or explore that issue with the witness on redirect, Mr. Cochran.
just checking my notes here, I'm almost in, we end up covering a lot of stuff as we go along.
I'm not pushing you, your case.
So, question of timing, you testified earlier that at some point you abandoned your adversarial role with the plaintiffs and their attorneys and began working with them. At what point in time did you feel like you had abandoned your adversarial role? Was it after the covenant judgment settlements were signed? Was it sometime when the offer was made? Was it when you were told by Mr. Ashbaum that you should not be sharing information with Philadelphia? What time did you feel like you abandoned your adversarial role?
When the covenant judgments were signed.
Other than getting to walk away from any personal liability, is there any other factor that you're aware of factored into your client's agreement to enter into the covenant judgment?
Yeah, the end of the litigation adverse to them. And this was, this was particularly true with Rose because, there were a lot of people I thought that were lined up to testify negatively about her, which would be emotionally hard on her to actually hear, these people saying, what an evil demonic person she was. And so, that the covenant judgments would mean that testimony would never occur. She would never have to counter that in a public courtroom. So.
Thank you, both. I don't have any other questions.
Thank you. Mr. Cochran, redirect.
Yeah. So, let me kind of pick up towards the end there. And you were asked a question about whether Philadelphia Indemnity had done anything to restrict you in terms of your defense of the case. Let me ask you a slightly different question on that. Did Philadelphia Indemnity essentially fail to provide any direction or guidance about what to do for most of the litigation?
Yeah, they were not. I mean, Ms. Holloman was not directing my activity in any way that I could discern.
But looking at it slightly different perspective, was it unusually lacking in terms of direction from Philadelphia Indemnity about how to proceed in the litigation, given your experience with other insurance companies?
No.
Well, let me give you a few examples. For example, did you get authority at any point prior to the consent judgments to set up a mediation?
I did not. Mr. Rosner may have, but I did not.
So rather than speculate about what Mr. Rosner did, let me ask you specifically, during the entire course of the litigation where you were the attorney hired by Philadelphia Indemnity to proceed forward, did you get authority and direction from Philadelphia Indemnity to arrange for a mediation?
Objection, compensation.
Let me read it. Overall, you can answer.
No.
And you've seen the litigation budget that you submitted on February 28th. During the point at which you submitted the litigation budget forward, did you ever receive word from Philadelphia Indemnity as to whether that was approved?
That I don't recall.
We haven't seen any documents yet here during this proceeding suggesting that they did. Agreed?
Correct. I haven't seen anything, and my memory on that is a blank.
And you were asked a question about your preparedness for trial and whether anyone had raised the issue Remember that line of questions just a little bit ago?
Yes,
Do you remember receiving letters repeatedly from my office asking you about taking your experts' depositions if you were going to present any experts at trial?
I do recall communications from your office about scheduling depositions. And they may have been with respect to experts as well, but I don't, sitting here today, I don't recall.
And
The
the
content
reason
of
why
it.
they never got set up was because you didn't have any that had been paid money, retained, and had worked up an expert report, right?
At the stage of the consent judgments, that is correct.
And you recall receiving correspondence regularly to my office offering to set up any depositions that you wanted to take.
I do recall receiving correspondence like that.
And you, for whatever reason, did not set up depositions in preparation for the trial.
That is correct.
And one of the reasons why you didn't do that is because Philadelphia Indemnity gave you no direction about whether your proposal to take depositions had ever been approved, right?
No, that's not, I'm sorry.
You know, this is a leading question, and now it just occurs to the court that this is a plaintiff's witness. So, Mr. Leveson, the court apologizes to you in retrospect because I sustained some objections from the plaintiff on the argument that they were leading, but you have a right to ask leading questions. Mr. Cochran doesn't.
I don't think there's any harm, Your Honor.
Yeah, I don't think so either, but
So, Your Honor, in your own behalf, I think your instincts were actually good because Mr. Molesino, being a representative of Philadelphia Indemnity, even if you're in a cross-examination, you cannot ask leading questions of essentially your own agent. So I think we're
I'm going to give both parties some leeway and latitude in this regard. But that last question was overly leading, so I'm going to sustain that one.
Yeah.
You can rephrase it though.
Yeah, right.
Thank you, Your Honor.
And essentially, Mr. Molesino, the thread was in follow-up to the questions about whether you were questioned about your preparedness, or whether Philadelphia Indemnity was questioned about whether it had prepared. You recall having regularly received correspondence essentially exploring whether you were going to take any depositions in the lead up to this trial.
I do recall correspondence from your office about scheduling depositions.
And just so we pinpoint this, we saw exhibit, I think you told me there was 648 was the September 21, 2012 letter from Rosman.
643.
643. Thank you. I'm gonna, let's see.
Thank you.
It's 648. I apologize.
648.
648 is the September 21, 2012 letter from Mr. Rosner. I'm going to have to take a look at exhibit 90. I think we show top hat on this.
Let's go off the record, Ray. We're off the record. Okay, back on the record.
Sure. And so we're looking at exhibit 98, and we're looking at the page that Steve Olson had signed. You see that that was executed on September 19th of 2012.
I do.
And the September 21, 2012 letter from Mr. Roth that was directed to me, was copied on that. And I'm going to mark another exhibit. Oops. Mark exhibit 132, and Mr. Balsino, let me hand that to you.
Thank you. Okay.
Maybe just give me a chance to read through that, get oriented.
Okay.
All right. So down at the start of the last full paragraph on the first page where it says, "While only 4 weeks away from trial," let me ask you about the substantive remarks on this. Is it, can you tell us whether it's true that the defense had failed to take a single deposition of the plaintiff's parents or child at that point 4 weeks away from trial?
That is correct.
Had the defense failed to conduct a single medical or mental health evaluation of any of the child plaintiffs or their plaintiff parents at that point 4 weeks away from trial?
Mr. You were asked and answered more than one.
Overruled.
That is correct.
Had the defense failed to take a single deposition of the battery of nationally renowned security, daycare, and child sexual abuse damages experts retained by the plaintiffs to prove their cases 4 weeks away from trial?
That's correct. There were no depositions taken at 4 weeks prior to trial.
Had the defense failed to present opinions or testimony from any expert supposedly retained by it to opine on behalf of the defendants, despite weeks and weeks of requests for depositions by the plaintiffs as of 4 weeks before trial?
We had not presented any expert opinions or reports. I am not clear about the second half of that.
Had the defense failed to serve an ER 904 submission of documents as of 4 weeks away from trial?
At this point, I don't know the answer to the question.
Had the defense failed to show any outward manifestation of trial readiness in any of the cases as of 4 weeks away from trial?
I don't know what that means. So,
Had you done anything to demonstrate that you were ready to take these cases to trial?
I don't know what that would look like.
So, well, for example, having taken depositions, having submitted an ER 904, things like that.
I don't know about the ER 904, but no, I had not taken any depositions.
We were asked questions on this thread about whether there was any alternative but to file declaratory judgment action about the policy limits in the lead up to trial. because you felt that there was an impasse as to the available policy. Do you remember those questions?
I do, and I do recall that sentiment.
Would you agree, though, that there was one option available to it, which was the Philadelphia indemnity and the defense could have taken the cases into trial and received a trial result from the jury, right?
Overruled.
Yes. I'm sorry.
You may answer.
Yes.
In fact, you were asked questions about whether you felt the number of the plaintiff's claims were simply in the nuisance value range. What discussion did you have with Philadelphia indemnity about simply taking those cases into trial to attempt to obtain a defense order?
At this point, I don't recall any discussions about that subject.
Well, what was your understanding of why Philadelphia indemnity didn't say as to claims like the steel and the steel claim right up front, the first one, strike that, we do it again. What was your understanding why Philadelphia indemnity simply didn't direct you to go in and present a defense at trial for the steel case?
I don't know. I don't recall having that discussion with Jackie Holloman, and I don't recall discussing why we didn't have that discussion.
Did you have a discussion with Philadelphia indemnity about the potential for Philadelphia indemnity being held liable for a judgment beyond their policy limits if the cases went to trial, a verdict was obtained beyond the policy limits, and there was a determination in supplemental proceedings that Philadelphia had engaged in a bad faith failure to prepare a defense?
No, I never had that discussion with Philadelphia.
You understand that there are situations where an insurance company will push a defendant into trial, a verdict is obtained beyond policy limits, and then it becomes a bad faith question about whether the insurance company had blown its policy limits by virtue of a bad faith act, right?
Well, I'll sustain that objection, but allow Mr. Cochran to rephrase it.
Essentially, Mr. Bolstina, are you aware of the legal potential for an insurance company to be liable beyond their policy limits if a verdict has been obtained beyond policy limits and the insurance company has engaged in some aspect of bad faith?
I was aware of that with respect to if there was a demand within policy limits and the insurance company rejected that demand, and then there was a verdict in excess of policy limits, that actually could open up the insurance company to having to pay the entire judgment for bad faith refusal to settle. That was my awareness at the time.
All right, and understanding and I appreciate that you've indicated several times that coverage issues and bad faith issues aren't yours. But regardless of whether there's a policy limit offer or acceptance, are you aware of the body of law which would hold an insurance company liable beyond policy limits if it's simply engaged in a bad faith failure to prepare the defense?
This is first of all, I don't think it's a great statement of the law, but this is a statement of the law to this witness to get in there, to make an argument and testify. I don't.
I'll overrule the objection. The question is essentially to this witness, are you aware of that body of law?
No.
You were asked questions about the negotiation process, and you correct me if I'm wrong, but I think you indicated that Mr. Ashwell at one point asked for some extra terms in there, and those were allowed by the plaintiff's counsel, right?
That's my understanding, yes.
And you have confirmed that in questions from Mr. Lavison that the decision about whether to negotiate was a decision made between yourself and Mr. Ashwell in representing your defendants. Is that right?
Right. I accepted Mr. Ashbow's advice on that issue.
Right. And he was representing defendant Steve Olson, and you were still representing all of the defendants.
Correct.
Including specifically Ms. Horrible, right?
Correct.
And so I just want to eliminate one issue. Was there any point at which you understood that the plaintiff was saying we refuse to negotiate any term?
I'm not aware of that. I'm aware of Mr. Ashbow saying we would like these provisions added and you agreeing to do it. That's all I'm aware of with respect to negotiation.
So you were shown the summary judgment ruling in the declaratory judgment action, and you saw that ruling came down over a year after the point at which the consent judgments were entered, right?
It was in 2013. I don't remember the month.
If it was October 2013, that would be essentially a year after the consent judgment was formed.
It would be about, yeah, that would be true.
And are you aware of whether that litigation still currently is active and active in the sense that it's still on the books and it's in a state capacity?
No. I do remember hearing about that ruling and actually reading it, but I have no idea what's going on with that litigation since then.
So I know you indicated that you read the complaint in the declaratory judgment action at some point. Do you recall that the affirmative defenses that were filed by the defendants and the plaintiffs, for that matter, centered around the fact that Philadelphia Indemnity has blown its coverage limits by virtue of its bad faith failure to prepare and failure to settle the case?
No, I did not see the answer in that case.
So let me just touch on a few quick points, and I appreciate you testifying a moment ago, and I want to make sure that I heard it correctly, that one of the incentives for settling the case prior to trial was to protect the defendant, Rose Hordahl, from what you described as many coworkers coming forward to testify negatively about her. Is that what I heard?
That is correct.
And in fact, I want to spend a whole lot of time. Let me just take a look at Exhibit 3 with you. Let me take a look at page 9 of the interview notes.
Are they numbered?
It is the one that up on the top will say page 75 in the upper right hand corner. So
Okay.
75 to 45.
And there.
And in the middle of the page it says relationships, and Rose Hordahl, and the person being interviewed with Dory Gore says did not like her, she should be in jail. And that's the type of testimony, or at least sentiments, that were out there from a number of the coworkers, as we did, right?
Yes.
Okay. And there were also concerns not only just about her being mean or not likable, but also that she had destroyed files during the course of investigation, right?
There were those allegations about a particular document, yes.
Overruled.
And that also Ms. Hordahl retaliated against parents who addressed concerns. You remember that?
Vaguely, that there may have been allegations about that. I can't say for right now.
I'm going to come back to 3 in a second, but I want to address the threat about the boy Nolan Dowley, ND, and you were asked questions about whether you thought it bolstered Mr. Tabor's credibility to have admitted that he sexually abused ND, right?
I remember that testimony from September, yes.
Right. But even here, you were asked questions a little bit ago. Did you think it bolstered Mr. Tabor's credibility that he voluntarily acknowledged having sexually abused ND, right?
I do remember saying that, yes.
And in fact, you testified that you felt that Mr. Tabor's, at least as you thought about it, credibility in acknowledging ND would help you in the defense of the claims, for example, by the young girls who have filed claims in this case, right?
Yes.
But isn't it true though that as to Tabor's voluntary admission of sexually abusing ND, that he had actually been found in the clinic with ND's hands in his pants and was confronted by one of his coworkers, Olivia Vasquez?
I don't recall that. And that's, I'm not sure why, if that were true, why Ms. Vasquez would not have come forward that, reported it at CPS or law enforcement, or it wouldn't have come up as part of the criminal investigation. So I'm just.
I'm glad you asked about that. Let's take a look at Exhibit 4. Did you ever depose Olivia Vasquez?
No.
Did you ever interview Olivia Vasquez?
I don't know. I did not interview Olivia Vasquez. Whether Peter did or not, I don't know.
You recognize her name as being one of the employees of the Olympia Early Learning Center.
Vaguely.
And you've acknowledged that being a prudent defense lawyer, you should have deposed co-workers and employees of the Olympia Early Learning Center, right?
Yes, those that I thought would be witnesses. Yes.
Right. So we go to the back of the document. You'll see Ms. Vasquez signed this June 14, 2012. You'll see on the front page that she describes her career with the Olympia Early Learning Center. And I want you to take a look at paragraph 10. As I recall, an incident that occurred when Eli Tabor was left alone with the children during nap time. I was returning from lunch, and Eli came to me and said that ND, a little boy in his classroom, Eli said he was sitting on the floor next to him, rubbing his back, when the little boy grabbed his hand, put it down his pants. I told Eli that he needed to speak with the boy's mother if that is in fact what happened, and it needed to be put in the logbook. CPS was called in on that matter, and everyone was led to believe that ND's neighbor was sexually assaulted. Ironically, Eli Tabor confessed to police that he had sexually assaulted ND and is currently in prison for that crime. Is there any workup that you did during the course of litigation which would indicate that that was not a true and accurate statement by Ms. Vasquez?
It might be. I don't know.
Nothing that you can provide for us as evidence here right now.
Yeah, correct.
Up a little bit, just there in paragraph 9, I want to follow up on threads that you were asked about Ms. Steele, Lisa Steele, and her daughter, JT. You'll see in Ms. Vasquez's declaration, paragraph 9, it says, in 2009, when the complaints by the Steeles were made, I did hear about them, but it was only because Eli Tabor came and told me himself. Eli told me that he was being put on admin leave and shifted over to the downtown location until the Thompsons cooled off. This is also how I came to find out about the allegations made by Christy Barbieri just 2 months later. Again, we as staff members were never informed about the Barbieri allegations. In my role as a parent, I was never informed by the OELC of the Barbieri allegations. You see that?
Yes.
Right. Any reason why anything in your workup of the case that would have call that into question, whether it happened that way.
No, I mean, I don't recall this aspect of the case, one way or the other.
I'm going to take us back to Exhibit 3 for a second. You remember there being co-workers who confirmed that Eli Tabor actually did provide the supervision for JT on the day in which she disclosed that she had been sexually abused, or that her vagina had been touched by Eli.
No, that contradicts what I recall from both the CPS and law enforcement investigations.
Let me see if I can refresh your recollection with the interview notes for Exhibit 3. And we'll take a look at page 106 to 245. Remember the cook, so the right question to you or Mr. Altman interviewed, right?
We both interviewed her at different times.
And you see there up on the screen, I've got the section that I'm hoping that we look at in red. So during the time when, first girl vagina allegations against Eli Nelson. Eli was closing the room down for Big Eli, who was sick. And Big Eli, by the way, is Eli Nelson, right?
Yeah, this is true of what this says in the interview notes. This is not true based on what I read in the CPS or law enforcement investigation.
Right now, I'm just asking you about what testimony was that would be forthcoming from employees at trial. So this is what you learned from your interview with Ms. Bradley Clifton, right?
No, these are Peter's interview notes.
I'm sorry,
These are Peter's interview notes. When I talked to her, she didn't say anything about Big Eli being sick and Little Eli being the one who was in that classroom that day.
Your associate, Mr. Altman, had memorialized these notes from Ms. Bradley Clifton, one of the employees, that Eli Tabor was the one who was covering for Big Eli Nelson, on the day in which the disclosure was made by JP, right?
That's apparently what's in these notes.
Yes.
That contradicts what's in the law enforcement and CPS investigations that were done immediately after.
I appreciate your testimony. Right now,
and these notes were taken several years after, and you know, I don't trust these notes as being a true account of what happened, based on the fact that it was reported and investigated by CPS and law enforcement immediately after, and that information is not contained in either of those extensive investigation reports.
I appreciate that advocacy, but you realize that the plaintiffs and plaintiffs' counsel were going to make a presentation to the jury during the Steele trial that the OELC administrators, including Rose Torpenhoff, had misdirected both CPS and the police, similar to what it did with Nolan Dowd, right?
I do recall that was an allegation that OELC had misdirected them, but I didn't find any factual support for that. And I'm not aware if you would actually, these are Peter's notes of his interview with the cook. I'm not aware of you interviewing the cook and having that information prior to when you got Peter Altman's notes.
Right, so all you're doing is advocating and speculating right now. I'm just gonna go ahead and ask you questions about what's factual in the record, all right? So let me direct our attention to 67, Exhibit 67, which is the claims note that we've looked at from Ms. Holman. And I've put a red mark around the spot that I want to specifically look at here, where Ms. Holman is communicating with her supervisor, Ms. Poucher.
I'm not going to object to this. This is probably been the same as on the claim notification.
It's in evidence, we've already gone over it.
Well, let's preface any question of the witness by asking the witness if he's familiar with or has seen this document.
Mr. Bolsino, I know that you haven't looked at this, so let me ask the specific question. I can follow up what I was just asking, which was that you understood that plaintiff's counsel was going to assert that OELC, specifically Rose Hordahl, steered the CPS investigation away from Tabor and on to Eli Nelson, right?
Yes, I think that appeared in the complaint.
So, by the way, you were asking Fred about Dr. Matt Logan's opinion that Eli Tabor was certainly capable of sexually abusing girls. And that opinion was shared by at least one of the co-workers there at Olympia Early Learning Center, right?
Possibly. I don't know.
Okay. If we look back at Exhibit 3, and so page 107 and 245. And I'll highlight this up on the screen. At least one of the co-workers felt that Eli could have abused the girls, right?
That's what somebody told Peter Altman when he interviewed them, yes.
All right. And in fact, the employees detailed the fact that Eli Tabor, that is, was a supervisor of both JT, Lisa Steele's child, and SRB, Christy Barbieri's child, right? Can you see that on page 102 of 245?
I recall that he definitely was with JT because they expressed objections to him at the time, but not around the time that the allegations were made.
Right. In fact, you were asked questions yesterday about Lisa Steele and whether she had made prior complaints at Exhibit 24. We shall find that in the interrogatory answers that Lisa Steele provided. I want us to take a look at interrogatory number 10, which starts on page 10.
That's it?
When we get a chance to look at both page 10 and page 11, where the entire duration of concerns expressed by Ms. Steele and her husband are notated, right?
Yeah, these are different from what I read, what I got from the OELC witnesses and read in the CPS and law enforcement investigation reports.
So Mr. Bolsino, though, I'm sticking specifically with this. I appreciate that you would have approached things differently, but you received these answers from Ms. Steele during the course of the litigation, right?
Yes.
And you knew from Ms. Steele's sworn answers that she was testifying that she had provided notice repeatedly to OELC about concerns with Eli Tabor, right?
Yes, although she didn't express these concerns when she was interviewed by law enforcement or CPS. And I think that they would have come out during the investigation if she had those concerns and expressed them about Eli Tabor.
Okay, thank you.
This is completely different from what she told law enforcement and CPS.
Mr. Bolsino, we're just going to deal with what the evidence is in this case.
I thought I was.
Well, that's not, none of what you're saying about what the police report says.
Okay, let's don't have argument. Let's just have question and answer, please.
So, Mr. Bolasina, did you take the deposition of Lisa Steele and ask her about her observations here?
No.
You were asked questions yesterday about whether there was any notice, as it were, about concerns with Eli Tabor's conduct, and you said nothing substantive, but don't you agree that Lisa Steele's reported concerns that she expressed at OELC would be substantive, the kind under the McLeod versus Grant County School District case that would give rise to notice and liability?
Yeah, if she had reported these to CPS and to law enforcement, I would be more concerned about them than just putting them in an interrogatory answer after she's filing a lawsuit.
By the way, did you depose a single CPS investigator in preparation for this trial?
No.
Did you go and speak to any of the CPS investigators in preparation for this trial?
I don't recall.
Did you depose any of the police officers in preparation for that trial?
No.
Did you speak to any of the police officers in preparation for that trial?
I believe I did.
Yeah. Which one?
I don't. I have no idea.
Do your notes or billings reflect that you did?
They might. I don't know.
So, by the way, if you were doing a quick compare and contrast of Ms. Steele's background and what coworkers said about Ms. Fordall, who would be the more credible person in your estimation as you were preparing your defense in this case?
I don't understand the question.
Do you recall Ms. Steele being a well-regarded manager within one of the state agency offices?
No, I don't.
And is that because you didn't take your deposition perhaps?
I probably asked about her jobs in Discovery, and I just don't recall the answers.
But you knew that there were a number of coworkers who were going to testify about concerns with Ms. Fordall's credibility, right?
Yes.
That's all I'm going to do.
Thank you. Mr. Levinson, recross.
Thank you, Eric. We're going to put up exhibit 644.
644?
Yes. Ma'am.
Okay.
Let's go to the top of the letter. What is, you can identify this letter.
It appears to be a letter from Steve Olson, care of me, to Philadelphia Insurance Company, dated July 20th, 2012.
Okay. Steve Olson is your client, and this point in time is represented by Mr. Ashbaugh.
I don't know. And I remember bringing in Mr. Ashbaugh after Steve Olson was sued individually. I don't recall exactly when that occurred. Probably at this point in time, yes. But I don't know that for sure.
Okay, if you go down to the end of the letter. The very last 3 paragraphs. There's questions about Philadelphia's willingness to go to mediation prior to September 2012. And this letter is written in July 2012. It says here, we understand that the parties are considering holding a covered mediation to which Philadelphia may be invited. The purpose of such mediation appears to be to allow the plaintiffs, the insured, and Philadelphia to discuss and attempt to reach an agreement regarding the amount of the available policy limits, with the hope that the claims can then be resolved within the policy limits of the future mediation. What do you remember about what was going on at this point in time that led to that statement by Philadelphia to, or to Mr. Olson?
I don't, well, I mean, at this point in time, there was an obvious dispute about the coverage limits.
So at this point in time, does it appear, does this help refresh your memory that Philadelphia is going to have two mediations, one to mediate the issue on the policy limits, and then after that was resolved, which needed to be resolved before there could be a mediation on the claims in the case?
This piece of correspondence does not refresh my recollection.
Okay. Does this help refresh your recollection as to whether or not Philadelphia was willing to participate in mediation in the case?
It does, and it may be shortly after this letter was sent that Mr. Rosner reached out to Mr. Cochran and proposed mediation. I mean, that sort of jives with my timeline about when Mr. Rosner was involved, when he reached out to Mr. Cochran and said that they were willing to mediate.
Okay, and do you remember how Mr. Cochran's office responded to the suggestion that mediation occur in July?
My memory is that it was the response was no, thank you. But again, those were communications that were going between Mr. Rosner and Mr. Cochran, and I was being CC'd on them, but the issue had been basically taken over by Mr. Rosner moving that forward.
Okay, does this letter reflect, if you read this letter, let's scroll down and see if you're a CC on this letter.
I think it's actually to me. The letter's to me, or to Steve Olson, care of me.
Okay, stop. Let's don't talk over each other. So let's have a question, please. Mr. Levison.
Let's go back to anything. So there's this letter, it's like Philadelphia's willingness to mediate both policy limit issue and then try to mediate and settle plaintiff's claims against the company.
Yes.
This is how many months before trial?
4?
Thank you. Is it unusual to wait until 4 months before trial to go to mediation?
No.
Happens all the time, doesn't it?
Sustain.
What's your experience?
Back
When mediation?
in that time frame, it was more common to mediate in the months before trial. These days, at least in the practice I have now, it's common to schedule early mediations in an attempt to resolve them. But that's a more recent phenomenon, probably in the last 5 years, with the risk management pools I work with.
Was there any chance, in your mind, was there any chance of settling the claims against your client by way of anything short of a global mediation, global settlement?
No. Well, possibly. When you say global settlement, there was certainly a possibility that certain claims would settle and others would not. But the main stumbling block to really anything settling was the policy limits dispute.
You testified about extra contractual liability on the part of the insurance company where they get a policy limits demand and they don't agree to settle the case with policy limits. and then end up in some circumstances having, say, a judgment in excess of the policy limit, if there is one, after a trial. Remember that questioning?
Yes, I do.
In this case, Mr. Cochran's office ever make a policy limit demand of $1 million policy limit demand to settle the case?
No, if the policy limits are $1 million, no, they never made a demand within that amount.
Well, we know they're $1 million today because Judge Layton said they were, correct?
I'm gonna object to the point there.
There's, I'll let the witness answer that overall.
I don't know everything that's transpired in that interplea. I only know what the Judge Layton order that I read 8 years ago, and that he appeared to agree that the policy limits were $1 million.
Just to confirm, there was never a $1 million, was there ever a $1 million policy limit demand in this case?
No.
Mr. Cochran asked you about extra contractual liability on the part of Philadelphia based on bad faith. Remember those questions?
I do.
So you understand that Philadelphia agreed to defend the defendant without a reservation of rights, willing to go to mediation 4 months before trial. It offered its $1 million policy limit. We can do all this evidence to me. And because there was this impasse on the policy limit issue, it filed an action in the U.S. District Court seeking a judicial determination of that policy limit. Where in any of that was Philadelphia, in your mind, in bad faith or potential bad faith in this case?
Gentlemen,
Sustained.
When you think of anything Philadelphia did was in bad faith in this case?
not even sure the relevance of this.
Sustained.
Are you aware of any legal duty of an insurance company to control the defense of a case, defense of their policy holder other than retaining competent defense?
You're asking about an area that I'm not familiar with. So I'm going to say no, but take that for what it's worth, since I'm not knowledgeable about this area of the law.
Okay, has anybody other than Mr. Cochran suggested that you're not a competent defense counsel?
Do you mean in my life?
I'll sustain the objection as to the form of the question, but you can ask it in another way.
Has anybody at all ever suggested you're not a competent defense counsel?
Oh, opposing counsel have made that claim about me on occasion when things get emotionally heated.
Okay. You have anything to suggest Philadelphia had any question or reason to question, I should say, whether or not you were a competent defense counsel to handle this case?
And based on my experience in doing it, no.
What experience are you talking about?
Well, at that time I had 2011, so I had been working on sex abuse cases as defense counsel for 17 years.
Okay. That experience include you working at Perkins Food Law Firm?
No, I did air crash litigation defense there. I only started working on these cases once I went to Stafford Fry Cooper in 1994.
Okay. That experience include your time as a clerk for the United States District Court in St. Louis?
I don't recall when I was a clerk working on any cases involving childhood sexual abuse. But I may have, but now we're talking over 30 years ago, so I don't know.
Do you have any obligation Philadelphia had to tell you that how to defend this case?
I'm not, but I'm also not familiar with that area of the law.
Okay. Was Philadelphia's handling of this case in terms of controlling the defense and telling you what you could or could not do, is that different than any other experiences you had with insurance companies when you're doing insurance defense work?
I don't believe so. I mean, it's been a while since I've worked with insurance companies, but at the time they tended to be pretty hands-off when it came to dictating how the defense should roll.
That's all the questions I got. Thank you.
Thank you. Mr. Cochran?
In terms of the obligations the Philadelphia indemnity had towards you, one of the obligations was to make sure it was paying your legal bills, right?
Objection, relevant.
What's the relevance of that, Mr.
I'm
Cochran?
just following up on what their obligations were on the case. It was also addressed by Mr. Lavis yesterday.
I'll allow the question overruled.
I don't know if that's what kind of obligation is that? It would be a contractual obligation, yes.
Hey, stop.
Sorry.
That's okay. Not your fault. It's Mr. Cochran's fault. So,
Accepted that.
okay. So the question is, what kind of obligation is that? No, I think
Mr. Bolsina,
he did. Yeah. Let's have a question, Mr. Cochran.
So, in terms of the obligations that Philadelphia indemnity failed to follow through on, one of them was paying your legal bills for almost a year, right?
That is my memory, yes.
$100,000 was outstanding all the way up to the point at which the consent judgments were circulated for consideration of the defendants, right?
I believe they made a big payment sometime in September of 2012. I don't remember when that payment came in and when that was in connection with the consent judgments.
Help us pinpoint that date.
Well, now I'm going to sustain an objection on the issue of whether that's relevant. So now I understand the objection. So I sustain the objection.
Right. I'll get it marked.
Okay.
And I'd be happy to give you a copy on it.
Okay. Sure.
And I'm
This document,
Oh.
you just ruled.
I'll hear a question and then I'll rule.
For the record, I would point out that Mr. Lathis actually asked yesterday about whether Philadelphia indemnity paid his legal bills on time.
Oh, I don't remember that.
I just asked him if he was fully paid. I did ask him that.
Yeah, it's in the court's mind, and my mind is the mind that counts. It's irrelevant.
Thank you. So just one last question there on this issue of mediations and whether anything refreshed your recollection about Philadelphia indemnity's willingness to mediate in July. Let me have us look at Exhibit 73 to remind ourselves.
Oh, I don't think I have that, so I'll put there.
You'll remember this being a John Masterson email on August 1st, 2012 to Paul Meyer, the OELC attorney, where Paul says, where John Masterson says, I spoke today with Mike Bolasina, OELC's defense attorney, about the attached letter from OELC's insurance company. It seems that the insurance company is dragging its feet on resolving the coverage limits issue in this case. Mike Bolasina asked if you would contact him to assist motivating Philadelphia insurance into action. Mr. Bolasina, that's consistent with what you remember and the time, correct?
I actually don't have a memory of that conversation with Mr. Masterson, but I do recall wanting Paul Meyer and Will Ashbaugh to get more actively involved in moving this forward.
Okay. for cause.
Further questions?
May the witness be excused, Mr. Cochran.
Yes, thank you.
Mr. Bolasini, thank you.
Thank you.
Excused. Court will, in just a matter of moments, break for lunch. And, well, in a matter of moments, we're going to go off the record just to discuss timing issues as it relates to this afternoon. So it's 11:45. Court's in recess until 1:30. Court is off the record. So what might the court expect this afternoon, Mr. Cochran?
Dr. Whitehill?
Okay. And then what are the parties' either expectations or requests for timing this afternoon? I'll hear from Mr. Cochran. How long do you want to go?
You want to go hopefully until we get Dr. Whitehill done, assuming that it's done before 4-ish.
Okay. What are your thoughts, Mr. Levison?
This is actually a witness that.
Oh, Mr. Rosner is going to. Okay, Mr. Rosner, what are your thoughts?
Yeah, we'd like to go until, as far as we can go.
Okay, we'll go till the latest that we'll go is 4:30. Because I want to make sure that people have a chance to get out of here and go over to their other offices and get wrapped up before 5. So we'll go till the very latest at 4:30. If the parties want to stop before 4:30, just let me know. That's fine with me, but we'll go up until 4:30 otherwise. Okay, okay, thanks everyone.
All right.
I have no idea. Right.
Have lunch.
Right. Okay, okay, so.